Good to go.
Is Ron on?
No,
Well, we've got a quorum, so, let's get our, meeting, rolling here. Michael, proof of notice?
I can confirm in accordance with Florida statutes that the notice was posted.
And, it appears we have a quorum, Ms. Schlattler.
John Walsh.
John Breeze.
Tom Craig.
Tom Craig is on.
Oh, hey, Tom.
Hey, how you doing?
All right. You didn't want to limp over here, huh? All right, glad you could join us. All right, we got 4. Awesome. Then I officially call this meeting to order. I'm going to start off with the president's report. I just want to say to everybody in the room and anybody who may be on Zoom, while we go through the agenda items, and I kindly ask that residents allow the board to finish their discussions first, and then we'll open up the floor to owners' comments. I'd like to keep the comments limited to 3 minutes so we can keep these meetings under an hour, which the last 2, we were successful. It was really good. So thank everybody for your cooperation on this. I'm going to start with the financial overview. We are still spot on our year-to-date operating budget, which is great. Our current Raymond James balance, this is where we keep our reserve funds. They're being invested, stands at $5,330,665 as of this morning. And the average current interest we're earning on these 3-month CDs is around 4%. It was 5% when we started, but where the interest rates are now, we're down around 4%. And our current operating account is $704,300. So we're in really good shape in those areas. Last Thursday, Michael and I took a couple of hours and we walked all the stairwells in both garages and in all the buildings, and we toured the entire roofs with a representative of Total Fire, who's taking care of all of our safety systems. And we were just getting a quick overview of the conditions of these 25-year-old pipes. There's a couple of them that we needed to repair right off, and actually Total Fire is out there right now doing one of those in building 5. And what these sand pipes are is the fire department has to come and fight a fire on each floor. They can plug in the city water to these sand pipes and then drag your hoses up and use them. We've got our 5-year annual inspection, which Total Fire will be doing. That's coming up in a couple of months, I believe, and that's where they actually take the camera and look on the inside as well, just not visual on the outside. I'm glad to announce that we currently have 0 delinquencies on our quarterly payments, right, Michael?
That's correct.
I mean, this is like the first time I can remember. It's the 19th of the month, and everybody's caught up. That's good job, everybody. I want to congratulate everybody on that one.
And January the 1st is coming around really fast.
Yeah.
And congratulate Michael as well for being so proactive and chasing people up.
Thank you.
Today, this morning, we had the elevator lobby tile cleaned and sealed, including the grout. And I just looked at the one here in building 5, and that looks really awesome.
Building 2
Looks really good. And thank you for mentioning that, John.
Yeah.
It makes a big difference. It looks really good. And also today, they're starting to clean the exterior windows around. You might have heard the beeping and seen the lift there. And I know that my windows look 100% better than they did first thing this morning. What else have we done? Oh, the pools and spas have new lighting to improve, the ambience at night. And also the lighting on the wall out here as you're headed towards the courts. Jeff went to replace they were actually, they're originals from 2020, and they had the round fluorescent lights in them, and when it was trying to take them apart, they just fell apart. So we put all new lighting on there, and it's indirect lighting, it lights up the column, and it looks really good at night. So it does look a lot better out there. What else have we done here? Condominium sales, there are currently 12 units for sale, with 2 pending, so we're around 6%. So we're in good shape there. And, that's the fun stuff. Here comes the not as fun stuff. A few months ago, we discovered that Bayfront Inc. had amended our association's governing documents. Specifically, the Declaration of Covenants, which is the top document that both us and our business partner have to follow. And it was primarily regarding shared expenses and their percentage of financial responsibility. They maintain that as the operating owner, they still have authority to make these amendments. And we strongly disagree with this, and as a result, we have filed suit in civil court. And Kevin Stoneburner was served yesterday with that paperwork. Jason will provide some more details on that later on in the meeting. But that's a little out of my pay grade.
You just wanted to steal my thunder.
So that's the end of my president report, kind of a short one this time around.
I have some questions, on finances. How was the 2024 audit?
Have we got that? We haven't got that yet, right?
Not bad,
I
no.
haven't seen it, but I'll follow up.
Are the auditors happy with the risk? I know they had a whole bunch of questions. Do you know if they've got all the answers?
As I have heard nothing, I can't
We
comment.
should probably, okay.
We haven't heard anything from them in a while, so I
Yeah,
think
I'll follow up.
yeah, okay, thanks. And, how was with our 2024 tax? So,
That was paid.
that was filed?
So that was the one that was like 24,000.
I haven't seen the filing. It's not on that folio, so hence the question.
yes.
So I'll follow up.
Okay, all right, thanks. And the only other question I have regarding our balance sheet and accounts is, and they, you know, huge improvement in transparency here. I just wonder if we should be showing a separate line item for the reserves for structural reserves and non-structural reserves. That's got a question mark at the end of it.
Will that software allow us to do that?
So it can be done if it's requested.
Okay, I guess it was just requested.
I am requesting, I think for transparency, I think it's good to see that number.
We'll get it done.
Hey, Michael, I think the camera,
What's that?
I think the camera's frozen. Mitch is just sitting there waving his hand up and down.
It's a little tense.
You mean restart it?
Yeah, just reboot.
All right, it's in the process of reboot, Tom.
Okay.
All right, under, let's check the agenda here so I follow this properly. New business. The board meeting minutes from 10/29 were sent out to the board. We need to approve those minutes.
I'll make that motion.
We'll need a second.
I'll second.
Aye.
Aye.
All right, unanimous. Approved, updated, restated owners rules and regulations.
So what we've done is we've clarified some of the items in our rules and regulations in
Include the use of an owl. Including, the use of our facilities for private functions. The rules have always stated the clubhouse may be reserved for special gatherings. The gym, pool areas, and courts are not available for private functions. That's always been in our rules and regulations. But recently, we've heard rumors there will be several pickleball leagues, men's, women's, mixed, whatever, coming in from other areas of Naples, using our courts this season, which concerned us. One of the first things we did was we contacted our insurance agent to see how does this play out. And she responded back, and this is quote, "Clubs are groups that include members who are not part of the Bayfront Condominium Association are not permitted to practice or play on our courts. Allowing non-residents to participate introduces unnecessary liability exposure for the community and ultimately for the residents we are responsible for protecting. This policy helps ensure the facilities remain safe, properly managed, and reserved for the enjoyment of Bayfront residents and their guests." So our insurance agent is saying, if somebody gets hurt, we're not covered. So that's where we've added some clarification to the gym, pool areas, and courts are not available for functions, private functions. We've added some clarification and the addition to the amenities section of our rules and regulations. And thank you, Jason, for drafting that for us. The sports courts are for personal recreational use of unit owners, approved occupants, and their guests only. The use of the courts for organized league play, including but not limited to scheduled team practices, matches, tournaments, lessons, clinics, or other group events, whether competitive or not competitive, and whether involving members or non-members or organized groups, is strictly prohibited. Non-member guests may use the sports courts only when accompanied by a unit owner or approved occupant who is actively participating in play during the same match or game. Unit owners and occupants are responsible for ensuring that their guests comply with this rule. Any violation may result in suspension of recreational privileges and or the imposition of fines as authorized under Article 8 of the Bylaws and Condominium Act. So we just clarified that somebody can't come in and commandeer our sports courts. And I have a question for you, Jason. If the board approves these new rules and regulations, they're to be sent to every owner. Is that correct? Is that a requirement?
That's correct. So
Okay.
you will distribute it. We'll actually also record it under a certificate of, amendment or statement.
Yeah.
And it will become effective, when distributed.
Okay. Thank you. So what we need to do as a board is have a discussion on this, and if there's no discussion, we'll open that up to comments from the residents. So I guess we need to make a motion first.
We're making a motion to adopt the
We're gonna make a motion to adopt the new rules and regulations. We'll need a second and then we'll discuss.
Okay. Not just for that.
No, the entire,
Okay,
thing that,
okay.
there's a bunch of other little
Yeah.
tweaks and stuff in there. I didn't go through the
I'm
entire,
happy to make that motion.
what's that?
I'm happy to make that motion.
Okay,
I'll second.
motion's been made and seconded. Any board discussion on that?
No, I think it's the right thing to do. Absolutely.
Okay, I've opened that up to residents. Any comments from residents?
We also have tenants rules and regulations. That should also, I think, be legitimate tenants.
With-
Regulations,
We hope to have that ready for the December meeting.
if we're mailing them out, should we mail them together?
I'm sorry, why are they any different? They should be included in what we.
Well, the tenant rules and regulations are a separate document from the owner rules and regulations. Okay.
So it's our obligation to send out the rules and regulations to the owners, or at least make it available on the website for them to see. So we shouldn't be sending out owners' rules and regulations for tenants.
Correct.
I have a question for Jason, under 8 sub D. Approved occupants, that would include tenants, correct?
That's correct, or maybe they are guests of owners who are
Okay.
staying long term but not paying rent, like family members, for instance, so anybody of that.
I make
nature.
mine pay rent.
As you should.
Yeah.
And I think I had a question over there.
Similar to what was already asked, but how will we determine guests? It's so if a resident has visitors or someone who they know as, they play.
Yeah, anybody.
Invite
can be a
me.
guest.
So then who can't use it then, if they just come solely and they don't know anybody here, or you have?
Well, what we were looking at is having apparently up to 25 people come with, one individual inviting, these teams from all over the city to come play and use our courts. That's not really, I got 25 guests showing up.
Okay.
So, but to prevent that, it says that the member or a resident or
Must be
approved
playing on the
occupant
court.
must be playing on the court with them, so that you don't have all of these, we'll say. Well, yes, but they need to be playing with the owner, so you don't have league play or clinics or other things going.
Do we want to put a limit on the number of guests? In case you get one guy on the court for 25 hours. I don't know.
Yeah, eventually you have to administer and enforce the
Yeah, yeah,
rules, and
yeah.
it might be more difficult,
Oh,
but
yeah.
I think this prevents the bigger concern you had, which is a massive group of
Yeah,
unknown people coming to use your courts and creating a liability.
I've seen it done where owners have 2 wristbands in one color, and they also give them 2 wristbands of a different color, so you don't identify who are the owners, residents, and who are the guests. And that limits it to 4.
Do you feel like you need that?
No, I don't know, I'm just tracking it out.
No,
We've
I don't
never
think so.
really had that.
tell us a
problem.
problem.
Yeah,
I'm sorry, we never really had any problem with it, as long as we had a tennis
Yeah.
courts, now with pickleball is another situation. But we never had that problem whatsoever, so I don't think we will, but you're absolutely right, if somebody brings in 20 people, it's a totally different thing than myself playing tennis with 3 other women. Bringing them in as my friends,
Yeah.
so that, we've done that in the past.
Yeah.
So I think that's perfectly allowed.
So then what will be our enforcement? Policies or going forward, like who determines who's out there and what do we do in those cases where there's a group that aren't with residents?
Well, if we have 25 people showing up to play out there, we've got Michael right there. That's going to read the rules and regulations, and he's gonna politely ask them to leave.
Okay.
How about 10?
What's that?
Is it limited to 25? How about if we see like 10 or 12 people there? That's also.
Well, I just threw that 25 out there.
Yeah.
Pick any large number you want.
Within reason.
So basically, it's really up to our discretion.
Yeah, well, I mean, we're gonna know if there's, a bunch of people from other parts of Naples out.
And how do they
show
get
up.
in to begin with?
What's that?
How do they get in? to
Well, they
begin
will
with?
be let in by the individual
Well,
who's
that's what
pulling
I'm
this
saying,
league
that's what
together.
I'm saying.
Yeah.
There is a league coming in,
Yeah,
it cannot be brought in just by one owner, one resident. It has to
Exactly.
be organized, and you can tell that is not. the
Exactly.
case. So
Exactly.
we will
Yes.
know.
There's also a serious insurance implication in this decision making.
Would it be wise then to define, say, 2 guests per owner and then we can relax it if we needed to. But just have something that would give Michael some teeth if he ran into a problem.
I would say, it's just my opinion, that. If something like that becomes a problem, then we can address it.
I agree.
Yeah.
Making a whole bunch of rules. and
We're
stuff
getting ahead of
upfront,
ourselves.
just in case, you know, I'd like to kind of keep it simple if I can.
That makes sense.
Okay. All right, end of discussion? Cool. All right, time for a vote. All those in favor?
I,
Aye,
Aye.
is unanimous. We're moving on. Jason, showtime.
There's no thunder.
My turn, I'll just stand up because it's
Okay.
better that I stand here.
Okay.
So hi, everyone. So yes, we have initiated suit against Bayfront Inc. Not to get too deep into the weeds, but this started with Mitch's request to Mr. Stoneburner that he contribute to his fair share of the waterproofing and painting of the shared facilities here at Bayfront. And I think after months and months of negotiating and after Mitch extended him much grace and time, what Bayfront Inc. ended up doing was changing the definition of shared facilities and shared expenses within the Declaration of Covenants. Now, he claims that it's simply an interpretation, right? He stayed away from the use of the word amendment as if he's not changing anything, but you will note, it's a public record, that there are underlines and strike throughs within your Declaration of Covenants that do in fact change the definition of shared facilities and shared expenses. He claims he has the right to do this because he claims to have the right to interpret and resolve any irreconcilable conflicts. And through some, I don't know, I would say, you know, legal reasoning that doesn't quite match up and he has put this out there into the public domain. And the concern is if this goes unchallenged, one, he will not contribute to his share of the shared expenses moving forward, as he's done for the past 25 years. And also, it's not challenged. What else will he change, claiming that there's some sort of conflict? And we don't want him to keep moving, you know, the commercial owners' share of the shared expenses onto the residential parcel owners more and more and more. That means higher expenses for you, to your detriment and Bayfront Inc.'s benefit. So we have in fact, you know, filed suit seeking a declaration from the court that what Bayfront Inc. has done is illegal, that it's in conflict with the governing documents, and we're asking them to deem this document null and void. And we've also asked the court to declare and make him perform the maintenance he's required to do, which currently is the painting and waterproofing. But of course, we've left out there the possibility of any other maintenance that might need to be performed. So that is the very basic essence of the dispute and what we've done. And we'll keep you informed along the way as much as we can. But he was just served with that lawsuit yesterday. And we envision there will be the typical litigation gamesmanship that involves motions to dismiss for various reasons that must be fought before a judge at a hearing. Eventually, they may get around to filing answer and affirmative defenses. So it's sort of a big substantive event, but it does take a long time. And the sort of standard track for a case like this could be 18 months in Collier County. So I don't want you to think this is all going to be wrapped up by December 31st of this year and we'll be painting by January. No, so it will take anywhere from 12 to 18 months at least. And again, as this progresses, the board will keep you informed and you know, let you know what happens. But that's where we are right now. So Any questions? I'll try to answer them. I don't want to give away anything attorney-client privilege. or
How, now,
confidential,
how did we find out, how were we notified that he changed those documents?
Well, he copied you on an opinion letter that he received from his legal counsel.
Yeah.
And attached to that was this legal opinion and this supplement to the Declaration of Covenants is what he's calling it, not an amendment.
Yeah.
So we went to
Okay.
review in the public record whether it had in fact been reported, and it had been reported,
Okay.
so that's. how-
So if he had not, because I put a lot of pressure on him throughout those months. Had he have not copied me on that email, how would we have found out?
My guess is, other than some accident, the
Yeah.
next time we would have found out about it is if somebody went to buy or sell a unit here, sought a title insurance policy, they would have pulled all of the relevant documents, and there would be this new supplement, out there. So that's how that might have gone if you weren't copied on that opinion in this supplement, so.
Am I right, it's 20 days to respond under Florida rule?
Those are the Florida rules of civil procedure, but you also have to recognize that those are fungible, right? So the courts want cases decided on their merits, not technicalities. So if it takes them 30 days, the court's not going to kick them out. And likewise, they have 20 days to respond. It doesn't mean an answer and affirm defenses. It could be a motion to dismiss of some kind for all the reasons they'll throw out.
What I mean is he can't ignore it. 21 days, he should have had something back to us, or
He should have.
done, yeah.
Right, and we might file a motion for default judgment at that point and set it for hearing, and at the very last minute, he might file something. And again, the judge is going to give that party the benefit of the doubt, because that's what courts are required to do, try to determine these cases on merits, not technicalities.
Thank you, Jason.
But yes, I'll go this way, yeah.
I was wondering, you mentioned something about, he said that the shared expenses and the percentages are put in interpretation. I mean, the man wrote the documents.
You're absolutely right. And he wrote them 25 years ago. And all that time.
Interpretation.
Right, and we of course noted that in our complaints.
Okay.
So that's what we did. It's just the same exact reaction right there. So, we hope to get this disposed of in your favor for probably the reasons that you're thinking of right now.
All right, thank you.
So what is the,
Oh, sorry. Go ahead.
what is the reason he has to share 20%?
What's the reason? So when this community was first created, and this was back in 2000, he created this declaration of covenants that said how the property would be developed, with a commercial parcel on the first floor and residential parcels on the top floors. And of course, you have some shared facilities, garages, support structures and walls and roofs and the like. But he created this. And he said that both the residential parcel and commercial parcel will benefit from various components of the property. Therefore, both parcels should share in the maintenance, repair, and replacement of it. Therefore, Bayfront Inc. established in that declaration of covenants percentages by which each parcel would share in various maintenance responsibilities and various components. So
The point is that he got something for it then. Right,
What's that?
he got certain rights for that, right?
he got certain rights for that. Well, he created it, right? He created
Yeah,
it.
he could
Yeah.
put zero then, the reason he put
He could.
20% is because he gotten things from the development that otherwise he wouldn't have not have gotten.
Right. Well, so
That's the part we need to think it through and point it to the court. And now he's trying to reverse the wheel and rewrite history.
it's important to note that he didn't receive anything from another developer. Bayfront Inc. was in fact the developer. So these are all things that Bayfront Inc. gave itself. And
Well,
this is
I mean,
a
I see
scheme
all
they
the stuff
established.
here, his sticky bar, his
Yeah.
people playing in our thing, I mean, there's a lot of nuisance stuff from him. And that's what he got, he got a lot of stuff, he got a lot of rights, otherwise he wouldn't have, not have gotten. We need to think it through, because the court may ask that question.
we've addressed it in our complaint, and yes, all these issues will be addressed in oral arguments, briefs, and the like as we move forward, so. Yes, ma'am, you've been great.
I might have missed it, but major projects can be started and we can go after him for the money at the end if we win. Right?
So let me explain, that, in the past, that's the way it's been done. And we have been very fortunate that after much negotiation and poking and prodding, that Bayfront Inc. has contributed its fair share when the condominium association initiated a project. But the fact of the matter is, the Declaration of Covenant says the operating owner, meaning Bayfront Inc., must initiate these projects. And then, of course, the residential parcel and commercial parcel then contribute their fair share as determined by the operating owner. What we didn't want to do is have the residential parcel initiate a project. We sought to collect the fair share from the commercial owner, only to have a court tell us, well, you had no authority to pursue that project on your own. So we could have taken that risk, but I think the board wisely chose, let's not, let's simply present this to the court for their determination, so. Yes.
So, the painting that we're talking about is the painting the breezeways and so forth?
Yeah, what his sticking point is the breezeways need to be completely redone. And that's a 3-step process with waterproofing and that sort of thing. He doesn't want to pay for any of that, but in the original documents, he's responsible for 20%.
And then let me just point out, the Declaration of Covenants, they say what they say. We're not seeking to have them changed or interpreted a different way. We want them enforced the way that we have operated under them for 25 years. So, and whatever they say, and we're fine with that. But what we don't want is one party having a unilateral right to amend and change this general scheme of development that's existed for 25 years. So.
I would say that there's a possibility that we may be able to do those breezeways for 18 months or more, that's a problem for the building.
Yes.
I think it's a problem for the value of our properties.
Yes.
But one thing that we are doing, and we're slowly picking away at it, and Jeff and his team are working on it, actually today, you were working on this, we are going around, it's gonna take us a little while to get it finished, but we're going around to every floor and every staircase, and we're just touching it up, just to make it look a lot better, especially building 4 and 2 seem to be the worst ones. So we're picking away at it.
I would also add, what this gentleman was saying was that I think what he got at the beginning was buyers. Because part of, I think, why initial buyers and even subsequent buyers would buy here, that was part of the decision-making process and understanding that he's, sharing the cost.
That's right.
Some of the things here, especially because he's, has a lot of commercial properties below.
And we have included in this complaint a number of counts or causes of action, as they're called. And of course, one of them is that the idea that he enticed or induced people to purchase
Based on
only to switch and change, at a later date. And that's at least, one of the causes of that. So,
Thank you.
all right, there are no more questions. I will have a seat. Maybe you can stick it down.
All right. Thanks, Jason.
Everybody.
Thank you.
All right, that's the end of actually, we don't have to vote, we've already voted, it's just an explanation of what's going on. Next item on the agenda is other business from board members.
Yeah, I'd just like to note that, as we probably all saw, there was pressure washing on the ground floor, very professional. Was that something that we pressured BFI to do? They did it out of the goodness of their hearts?
Yeah, a lot of goodness there, I guess.
Yeah. Okay, just got to congratulate you for doing that. Thank you. But they look a lot better, I think.
Yeah.
3 hurricanes later.
Yeah.
A lot of that brine and salt and stuff is going. Thank you.
Okay, homeowner comments.
On the second floor of on my building side looks much better since they've been painting the hallway. Considerably better, even though it's a touch-up, I realize, but it's much better.
Thank
And
you.
the other thing, that the lobby looks great, it will get dirty again, but still, it looks great. It had never been done for a long, long time. I wish they would do the elevators inside too.
They will
because
be here
there's a
tomorrow.
stark difference between the
Yeah,
elevators.
tomorrow, that's scheduled for tomorrow.
With the elevators?
Yeah,
But thank you for doing it.
You're
It looks
very welcome.
much better.
Yes.
Because they did such a great job, you can tell the elevators need it.
Yeah, the two different colors now.
I have a comment about the dogs again. I went to a friend's house at the Aura, the new 14-story building on the corner of Davis. And there were dogs there, so I was just asking the question. They have a pet rent policy. So renters pay $50 a month to have their dogs in the unit. Just. There's something just to bring up that thought, maybe there's something that we could.
The,
adopt.
our current rules and regulations are supposed to be not, allow renters to have dogs, but in today's world where everybody's got an emotional support animal, that just gets into, some gray areas, and perhaps you might be the expert on this to speak about it better than me.
I think that is a decision for you all, the community, to make, you know, residents deciding,
Yeah,
you know, okay, maybe the rule existed once upon a time. And maybe it's time for a change, or maybe not, but then, yes, you also have this, the advent of the emotional support pet. And more animals are finding their way in the communities, you know, by that route. Despite, you know, rules and restrictions. against
you can get a certificate guaranteed within 4 hours off the web. They have attorneys in every single state that will write one up for you. You just gotta fill out a questionnaire and answer some questions, and so while we're on that, I have another question for you, Jason. I wasn't on the board, it was 3 years ago. There was a renter that was here for a month that brought her dog up beside the pool. And from my understanding, if the dog made a mess, pool, whatever, the pool has to be drained and, you know, city code drained and whatever. And a board member at the time said you can't have your dog up here by the pool. And there was a major meltdown, yelling, screaming, threatening. She came down into here. And the cam at the time yelled and screamed and threatened that she's gonna sue the place. And it just kind of ended. With something like that, say a situation like that happened again. I mean, what legal right would we have? Because, you know, that's gonna be an expensive deal to drain that pool and have it professionally cleaned. Do we have any rights there, or is it gonna be renters' rights?
If the person is an authorized occupant or guest and entitled to be here, then there's nothing you can do in the moment. You couldn't call law enforcement
Right.
and have them remove a trespasser. Enforcing a dog rule, obviously that's a civil matter, not a criminal matter. Law enforcement is not going to assist you with that. So I recommend you firmly but politely tell them that the rule is this and they're not to have their pet. And if they disregard it, I don't suggest you get into a verbal or physical altercation.
Don't throw them over the railing.
No, do not do that. But, you know, fortunately, at that point, you're now left to civil legal remedies. You could initiate fines, you could suspend use rights. You could initiate suit seeking to enjoin their current and future behavior. And yes, if their rule violation, you know, resulted in additional expenses to the association, you could sue to recover them. Even if, maybe let's say it's not a rule violation, let's say somebody did have an emotional support pet here pursuant to federal and Florida guidelines, yet the pet dirtied the swimming pool and you had to drain it and clean it and refill it. you could still, sue to recover the expenses caused by their failure to curb their pet.
Okay. That just popped into my head when we were talking
Well,
about this.
hopefully,
Probably done very familiar
Wouldn't
with.
it be just easier? There are a couple of rules, the big poster that says no diving, no glass, no whatever. Couldn't we just say no dogs allowed in the pool?
I believe it's
That's all
already,
there is to it.
I believe it's already on there.
I'm not supposed to use the pool, though.
Believe it or not, there are people that ignore
Well, then there's mine.
If I remember correctly, I think that was an emotional support or a service dog. If we're talking about the same dog, Mitch.
Yeah, it was.
But you never proved it.
Yeah, prove that. That was the point.
Yeah.
I think I looked it up. I think it was registered with the state, if I recall.
Okay.
In a property I'm very familiar with, they have a rule that if anyone brings a glass and it breaks, then the pool gets drained, they are responsible for it. If a kid's diaper comes off and you have things floating around, exactly the same, the cost goes back to the perpetrator.
And just, you could have rules ad nauseam, right?
Sure.
That would be covered simply by common law, like you wouldn't need a law that says if you break a glass, you pay for it, if you mess up the swimming pool, you pay for it, that exists regardless whatever rule,
Okay, you don't need a rule.
I just don't want you to have a
No,
600-page
Yeah.
binder.
Yeah.
Neither do I.
Keep it simple.
Same subject, but different area. I know it's on the parking garage, first floor, and I know it's shared by not civilians, by outside people, so it's. But the people, I kind of think I know who is doing it, but I didn't see the dog actually do it. But pooping in the garage and they leave it, or on the walkway into BJ's and they leave it. Would it be so bad having nice small signs posted on some of those white pillars in the garage, just saying?
We don't, that's
Just
the
the way to
first, the
look.
ground floor of the garage, that's 100% Bayfront Inc. control. We don't have any control over the ground floor.
Oh, true. But it's tacky.
Of course.
Gross.
I have a question about the tenant evaluation, no procedure. It pretends only for tenants that come in for their winter season, usually come for 30 days. And one of them, when I sent this stuff to her, she called me pretty upset, saying, why do I have to provide my marriage certificate? I paid everything up front. Why do they want my personal financials? So I know the idea is good, the idea is great what you guys did. But there should be some difference between people that come prepaid for 30 days. Compared to people that buy a unit for $2.5 million and stay with us forever.
Well, I think that our tenant evaluation is kind of pretty much the same one that every association uses. I mean, we're not doing anything different than what everybody else is doing. That we just had, the first time in my knowledge, we had just rejected a potential tenant for filling out false information. She had lied about her address, her business address, which state she was coming from. It was some sort of con going on. And if we didn't have a tenant evaluation, I don't know what scheme she and the person she was with was running, but she'd be here right now.
Yeah, right, no, I'm, like I said in the beginning, I said, I understand why you guys doing it and it needs to be done. But when someone comes for 30 days in the season, prepaid. It's gotta be treated differently than someone buying a condo for $2.5 million and gonna stay with us forever. It's gotta be treated as someone that goes and apply for the FBI, it's gonna be even more stringent, and if you apply for CIA, you're gonna get even more than that. So I don't think it's fair to treat them, there's a lot of personal information. To treat someone coming for 30 days prepaid, as someone's gonna stay with us forever and has to buy a condo for $2.5 million. Look, why do we need marriage certificate? Saying, what are we, in the middle ages now, they're gonna punish single, they're gonna. punish, separate
I mean,
people.
I vet the applications and I've never seen
No, I don't.
That's what she told
I've
me.
never seen a marriage that we see driving licenses.
Yeah, and the
And as
financial.
foreign, we see passports.
So all I'm saying is, I'd like the board to reconsider. The people coming here for short time from January to April. To see if there's something really over there. That's my point, and my point is not to go crazy and swing down.
That
I just want to say one thing. I applied because I was gonna rent before. Then I decided to buy and I did fill out the thing and it didn't have anything that wasn't what.
This is
other
the
applications
tenant
were.
evaluation.com, is it new?
Yeah.
Sorry?
It's 6 months or how?
Yeah, there's a new site that's being used to streamline it. Before it was all
Manual.
paper.
Yes.
And this is, but I've never seen a request, I've never seen a marriage license in there.
So who do I send it to? I'll
So-
ask her for proof of that, I will send it to, I send it to Mike?
Yeah.
You can send it to me, or you can call the 305 number, which is tenant
No,
evaluation.
it's automatic thing, you never get to talk to a person then.
Okay. But just to elaborate a little bit more, seeing as you and I spoke about this yesterday. Your applicant also refused to provide a social security number.
Yeah, I don't know, the social security, I'm not in that business, maybe you needed to in order to check background. Or whatever, I'm not pushing on that. And in today's hacking and personal identification, stealing, and there's a lot of problem with this, so people a little bit cautious. But I was talking more about the financials. Why do we need so much financial information if the person prepaid and is coming just for 30 days? And then the marriage thing, I mean, it just, we need to just reconsider that.
The challenge we have then is that we have multiples of differentiations of who the people are, how long they're staying for, what their income levels are. And, you know, we work with one format.
But the board will take, your, what you just said into consideration.
Thank
Any other homeowner comments? This is 3 in a row, under an hour. If there's nothing else, we're gonna need, a motion and second to adjourn.
I will make that motion to adjourn.
Second.
All those in favor?
Aye.
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 Meeting is adjourned.
Thank you.
Thank you.
Thanks, everybody.
Oh, okay. I.